Hello and welcome. My name is Alan, and we are back with more notable names in Pacific Islander and Asian American history. This is the last of such videos for 2025 of Asian American Pacific Islander notable names. But anyway, today we are looking at Wong Kim Ark and a court case he was involved, dealt with him. But anyway, let's go ahead and jump into this. First, we have from the Zen Education Project, Wong Kim Ark. March 28, 1898, the U.S. Supreme Court issued a landmark decision in the United States versus Wong Kim Ark, holding that children born in the United States, even to parents not eligible to become citizens, were nonetheless citizens themselves under the 14th Amendment of the U.S. Constitution. Born in San Francisco to Chinese immigrants who were barred from ever becoming U.S. citizens under the 1882 Chinese Exclusion Act, Wong Kim Ark was denied re-entry to the United States after a trip to China, on the grounds that the son of Chinese national could never be a U.S. citizen. Wong sued the federal government, resulting in the Supreme Court's seminal decision that the government could not deny citizenship to anyone born in the United States as per the 14th Amendment. So yeah. Let's look at Oye. What they have to say here. The case was argued March the 5th, 1897 and decided March 28, 1898. The United States versus Wong Kim Ark. The Chinese Exclusion Acts denied citizenship to Chinese immigrants. Moreover, by treaty, no Chinese subject in the United States could become a naturalized citizen. Wong Kim Ark, who was born in San Francisco to parents who were both Chinese citizens who resided in the United States at the time, and at age 21, he returned to China to visit his parents who had previously resided in the United States for 20 years. When he returned to the United States, he was denied entry on the ground that he was not a citizen. The question was, is a child who is born in the United States to Chinese citizen parents who are lawful permanent residents in the United States a U.S. citizen under the Citizenship Clause of the 14th Amendment? Thus, our conclusion was, because Wong was born in the United States and his parents were not employed in any diplomatic or official capacity under the Emperor of China, the Citizenship Clause of the 14th Amendment automatically makes him a U.S. citizen. Justice Horace Gray authored the opinion on behalf of a 6-2 majority in which the court established the parameters of the concept known as jus soli, the citizenship of children born in the United States to non-citizens. Justice Joseph McKenna took no part in the consideration or decision of the case. But yeah. 6-2 decision. 6 that agreed that, yeah, children born in the United States are citizens, and 2 against. The worst it could have been is 6-3 if McKenna had took part, but he didn't. So yeah. Very much. The court was like, it's clear. The 14th Amendment says, hey, if you're born in the U.S., even if your parents are not citizens or naturally born citizens, if you are born in the U.S., you are a citizen. Uh, bu- 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 Yeah, the holding, according to Wikipedia, a child born in the U.S. to alien parents is still a citizen. And the phrase subject to the jurisdiction thereof should be interpreted in light of the common law. At the time, our Chief Justice was Melville Fuller, with Associate Justices being John Harlan, David Brewer, George Shiras Jr., Rufus Peckham, Horace Gray, Henry Brown, Edward White, and Joseph McKenna. And remember, McKenna didn't even take part, so yeah. So yeah. Which, even today, what they're doing in deporting these U.S. born children of immigrant parents is entirely wrong. But let's look at what we can find on Ark here, because I tried to look up just the name, and there was a lot on the case, but almost nothing on just Wong Kim Ark himself. He was the first Supreme Court case to decide on the status of children born in the U.S. to alien parents, and established an important precedent in its interpretation of the Citizen Clause of the 14th Amendment to the Constitution. Wong Kim Ark was born in San Francisco in 1873 and had been denied re-entry into the U.S. after a trip abroad. Under the Chinese Exclusion Act, a law banning virtually all Chinese immigration and prohibiting Chinese immigrants from becoming naturalized U.S. citizens. And of course, he challenged the government's refusal to recognize his citizenship, and the Supreme Court ruled in his favor, holding that the Citizenship Clause should be interpreted in light of the common law. The court's dissenters argued that being subject to jurisdiction of the United States meant not being subject to any foreign power. That is, not being claimed as a citizen by another country. Dual citizenship is what they're claiming you cannot have. Jus sanguinis, inheriting citizenship from a parent, an interpretation which, in the minority's view, would have excluded the children of foreigners happening to be born to them while passing through the country. But we know his parents had already lived there for 20 years before moving back to China. In the words of a 2007 legal analysis, the events following the Wong Kim Ark decision, the parameters of the jus soli principle, as stated by the court in Wong Kim Ark, have never been seriously questioned by the Supreme Court and have been adopted as dogma by lower courts. A 2010 review in the history of the citizenship clause notes that the Wong Kim Ark decision held that the guarantee of birthright citizenship applies to children of foreigners present on American soil. So yeah. Let's see, what else can we find here? It mainly dealt with granting citizenship to all the slaves because they had so many generations in the U.S. after slavery was ended. But Senator Jacob M. Howard of Michigan was the one apparently who proposed it as an amendment to the joint resolution from the House of Representatives, which had framed the initial draft of the proposed 14th Amendment. Prior to that case, and of course we've talked about the Chinese Exclusion Act. Like I've said, we see more and more the racist underbelly that has underpinned the U.S. for so long. Okay, Wong Kim Ark, born in San Francisco, California, at 751 Sacramento Street, the address of a Chinatown business maintained by his merchant parents. Wong Kim Ark was born around 1868 to 1873, it looks like. Then they say to after 1931. I don't know if they're just indicating that's his year of death or what, but anyway, various sources state or imply that his year of birth as being 1873, 1871, or 1868, as we could see from this up here. His father, Wong Siping, and mother, Li Wei, immigrated from Taishan, Guangdong, China, and were not U.S. citizens, as the naturalization law of 1802 had made them ineligible for naturalization either before or after his birth. Wong did not become a merchant like his father, but worked as a cook in Chinatown restaurants. In 1889, in his late teens, he left for China with his parents, who decided to repatriate to China and their ancestral village in Taishan, Ongsing. While in Taishan, he married Yi Shi from a village near his familial one. Returning to the United States in 1890, he left behind in Taishan not only his parents but also his wife, who gave birth to their first son after he returned to California. Under the Chinese Exclusion Act of 1882, he was a laborer who, as a laborer, could not bring his wife to the United States. Upon arrival alone in San Francisco in 1890, he was readmitted on the ground that he was a native-born citizen of the United States, but only after an unnamed Bureau of Immigration official left a note in his file questioning the veracity of his claim of birth in the United States. In November of 1894, he sailed to China for another temporary visit to rejoin his wife and his family's village in Taishan, Guangdong, and met his oldest son for the first time, and his second son was conceived. But when he returned in August of 1895 by the SS Coptic, he was detained at the port of San Francisco by the collector of customs, who denied him permission to enter the country, arguing that Wong was not a U.S. citizen despite his having been born in the U.S., but was instead a Chinese subject because his parents were Chinese. Wong was confined for 5 months on steamships off the coast of San Francisco while his case was being tried. According to Sawyer, the San Francisco attorney George Collins had tried to persuade the Justice Department to bring a Chinese birthright citizenship case before the Supreme Court. An article by Collins was published in the May-June 1895 American Law Review criticizing the Luk Tin Sing ruling by Judge Field and the federal government's unwillingness to challenge it, and advocating the international law view of jus sanguinis citizenship. Eventually, Collins was able to convince U.S. Attorney Henry Foote, who searched for a viable test case and settled on Wong Kim Ark. With the assistance of legal representation by the Chinese Consolidated Benevolent Association, Wong Kim Ark challenged the refusal to recognize his birth claim to U.S. citizenship, and a petition for a writ of habeas corpus was filed on his behalf in federal district court. The arguments presented before District Judge William Morrow centered on which of two competing interpretations of the phrase "subject to the jurisdiction thereof" in the citizenship clause should govern a situation involving a child born in the United States to alien parents. The U.S. government claimed that the subject of jurisdiction thereof meant to be subject to the political jurisdiction of the United States, an interpretation based on international law which would exclude parents and their children who owed allegiance to another country via the principle of jus sanguinis, citizenship inherited from a parent. They argued that Wong's claim to U.S. citizenship was ruled out of the Supreme Court's interpretation of jurisdiction in its 1873 Slaughterhouse Cases ruling. The question of citizenship status of U.S.-born children of alien parents had up to this time never been decided by the Supreme Court, leading Judge Morrow to decide that the remark about citizenship clause in Slaughterhouse was obiter dictum. The government also cited a similar statement in Elk versus Wilkins, but the judge was not convinced by this argument either. Wong's attorney argued the phrase meant subject to the laws of the United States, comprehending in this expression the allegiance that aliens owe in the foreign country to obey its laws, an interpretation based on the common law inherited by the U.S. from England that would encompass essentially everyone born in the U.S. via the principle of jus soli, citizenship based on place of birth. Wong's attorneys cited the Luk Tin Sing case, and the district judge agreed that in the absence of clear direct direction from the Supreme Court, this case definitely settled the question for citizenship for Wong and others like him as federal courts in the Ninth Circuit were concerned. The judge saw the Luk Tin Singh case reaffirmed in the Yi Fuk Singh case, and noted further that another part of the Supreme Court Slaughterhouse case's opinion said that it is only necessary that a man should be born or naturalized in the United States to be a citizen of the Union, concluding that the Luk Tin Singh case constituted a controlling precedent in the Ninth Circuit. Judge Morrow ruled that subject to the jurisdiction thereof referred to being subject to U.S. law, the first of the two proposed interpretations, and on January 3rd, 1896, the judge declared Wong Kim Ark to be a citizen because he was born in the U.S. The U.S. government appealed the district court ruling directly to the Supreme Court. According to Salyer, government officials, realizing that the decision in this case was of great importance not just to Chinese Americans but all American citizens who have been born to alien parents, and concerned about the possible effect of any early ruling by the Supreme Court on the 1896 presidential election, delayed the timing of their appeal. So, as to avoid the possibility of a decision based more on the policy concerns than the merits of the case. Oral arguments before the Supreme Court were held March the 5th, 1897. Solicitor General Holmes Conrad presented the government's case. Wong was represented before the court by Maxwell Everts, former U.S. Assistant Attorney General J. Hubley Ashton, and Thomas D. Riordan. And the Supreme Court considered the single question in the case to be whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects to the Emperor of China but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States. It was conceded that if Wong was a U.S. citizen, the acts of Congress known as the Chinese Exclusion Acts, prohibiting persons of Chinese race, and especially Chinese laborers from coming into the U.S., do not and cannot apply to him. But yeah, 6-2 decision issued in Wong Kim Ark's favor on March 28, 1898. Let's see. Dissenting opinions, Melville Fuller and John Marshall Harlan. Contemporary reactions. What others thought at the time. In an analysis of the Wong Kim Ark case written shortly after the decision in 1898, Marshall B. Woodworth laid out two competing theories of jurisdiction in the Citizenship Clause and observed that the fact that the decision of the court was not unanimous indicates that the question is at least debatable. Woodworth concluded, however, that the Supreme Court ruling had laid the issue to rest, saying that it is difficult to see what valid objection can be raised thereto. Another analysis of the case published by the Yale Law Journal favored the dissenting view. So, let's see. An editorial published by the San Francisco Chronicle on March 30th, 1898 expressed concern that the Wong Kim Ark ruling issued 2 days previously may have a wider effect upon the question of citizenship than the public supposes, specifically that it may lead to citizenship and voting rights not only for Chinese but also Japanese and American Indians. The editorial suggested that it may become necessary to amend the federal constitution and definitely limit citizenship to whites and blacks. Bit racist, but like we said, there's that underbelly of the U.S. racism. Before Wong Kim Ark, the Supreme Court held in Elk v. Wilkins that birthplace by itself was not sufficient to grant citizenship to Native Americans. However, Congress eventually granted full citizenship to Native Americans via the Indian Citizenship Act of 1924. So while they are recognized as their own people, they are also within the U.S. and thus are U.S. citizens. Let's see. It looks like it's pretty much been, since the 1990s, controversy has arisen in some circles over the practice of granting automatic citizenship via jus soli to U.S.-born children of illegal citizens, controversially dubbed the anchor baby situation by some media correspondents and advocacy groups. Public debate over the issue has resulted in renewed discussion of the Wong Kim Ark decision. Some legal scholars opposed to the idea that jus soli should apply to the children of illegal aliens have argued that Wong Kim Ark precedent does not apply when alien parents are in the country illegally. John C. Eastman, a senior fellow at the Claremont Institute, has argued that Wong Kim Ark does not entitle U.S.-born children of illegal aliens to gain automatic citizenship because, in his opinion, being subject to the jurisdiction of the U.S. requires a status of full and complete jurisdiction that does not apply to aliens who are in the country illegally. Eastman further argues that Wong Kim Ark decision was fundamentally flawed in the way it dealt with the concept of jurisdiction, and that the Indian Citizenship Act of 1924, which followed, would not have been necessary if Congress had believed that the Citizenship Clause confers citizenship merely by accident of birth. Unfortunately, there's always going to be racist dickheads who doubt and look for bullshit reasonings that, no, this is not true. So yeah, Eastman, shut the fuck up. You don't know what the fuck you're talking about. A similar analysis of the jurisdiction question has been proposed by Professor Peter H. Schuck of the Yale School of Law and Rogers M. Smith, political science professor at Yale. According to law professor Lino Graglia of the University of Texas, even if Wong Kim Ark settled the status of children of legal residents, it did not do so for the children of illegal residents. Graglia asserts that the case weighs against automatic birthright citizenship for illegal immigrants because the court denied such citizenship for an analogous group, namely children of alien enemies born during and within their hostile occupation. What hostile occupation? God, he's such a dumbass. Countering this view, Garrett Epps, professor at the University of Baltimore, has stated that in the case of the United States versus Wong Kim Ark, the United States Supreme Court held that his guarantee of birthright citizenship applies to children of foreigners present on American soil, even if their parents are not American citizens, and indeed are not eligible to become U.S. citizens. Epps further notes that, as a practical matter, the American-born children receive recognition of their citizenship regardless of the immigration status of their parents. Abso-fucking-lutely. In Epps' opinion, the sponsors of the 14th Amendment were unwavering in their insistence that the citizenship clause was to cover the children of such undesirable immigrants as Chinese and Gypsies, and he views the Wong Kim Ark ruling as an unexceptionable matter at reading the drafter's intent. Judge James C. Ho, appointed the Fifth Circuit Court of Appeals in 2018, has expressed a similar view to that of Rodriguez, saying that birthright citizenship is guaranteed by the 14th Amendment. That birthright is protected no less for children of undocumented persons than for descendants of Mayflower passengers. He also argues that those who claim the citizenship clause was not in fact intended to confer citizenship on children of aliens are disregarding the substance of the 1866 Senate debate over the proposal to add this language to the 14th Amendment. Exactly. I mean, it's pretty clear. Those who set up the 14th Amendment were like, look, it's got to apply for all. That's why they said, no persons born in the U.S. I mean, look up the actual wording of the 14th Amendment. Citizenship. Defines citizenship for all persons born or naturalized in the United States and subject to its jurisdiction. It's the 14th Amendment, Section 1. All persons. It does not say of any type. All persons born or naturalized in the United States and subject to the jurisdiction thereof, subject to the U.S. laws, are citizens of the U.S. and of the state wherein they reside. I think it's pretty goddamn fucking clear. But, of course, there's going to be racist shits like Stephen Miller who want to push back on this belief because he's a Nazi asshole. We'll go ahead and add this to the list of documents we can look at. Well, come on now. There we go. But anyway, yeah. See, they're already trying, they've been trying to pass legislation to prevent the 14th Amendment citizenship clause dealing with certain people. It does not limit the scope of anybody. If you are born in the U.S. and are subject to its laws, yeah, you're a citizen. And usually, if you're born in the U.S., you are subject to the laws. Duh. So yeah, these racist dickheads who are trying so hard to remove it can go shove it. Anyway, we'll go ahead and end this episode there. As always, educate thyself, think, read, study, learn. Someone tells you something you have trouble believing, ask them to cite their sources. I'll be putting these links and sources in the description box below the video. Thank you all for watching. I'll see you all in the next one. Until then, later.